Hey guys, welcome to my channel. Okay, so I have a video I'm working on with all the updates since my last Lori Daybell video. Sorry guys, I'm a little behind, but I have a video, like I said, I'm working on that just has them all kind of together, compiled in one video. But I'm working on that right now. But I wanted to get this one out to you because it just happened today, earlier today. And it's Lori making her first appearance in the Idaho court. So it's pretty just, it kind of makes you mad seeing her smile. And it's almost like she's not taking this serious. Like she doesn't realize there's two kids' lives here that we're talking about. And she just laughs and smiles like she's hanging out with friends or something. Like I don't think she realizes the seriousness of what's going on. And like I said, I don't know what to think. If the kids are all right, I guess the hopeful side of me is hoping that she's just this stubborn little narcissistic sociopath that just doesn't want to lose, like doesn't want to just give up the kids, just is playing this game like you're not going to get them because they're mine. And I'm just wondering if she's holding out because she really strongly believes that July it's going to be this end of the world, the second coming of Jesus Christ, the end of the world type thing. So I don't know if she's holding out till then and really believing that, and just maybe the kids are safe somewhere and she just is just like, no, the government's not going to take them. That these are my kids. You don't have no right to them. Like, is she playing that kind of game, or is there something more serious going on? And I know most of you guys think that they're not alive anymore, and I know. I mean, I'm not stupid as far as I know the chances of them being alive are small, but I still think there is still a chance that maybe they are alive. I guess I just want to hang on to that hope. And I know it's a small chance. I know it's really small. I mean, the more time that goes by, it's just the chances are smaller and smaller. And I know the fact that Tylee's almost 18 years old already, you think that with all this going on, if they were alive, that she would come forward. I mean, she would be able to escape or come and bring JJ, and she would do it. But what if they have her so brainwashed, wherever, if they're in this cult or wherever they are, that she's so brainwashed and she believes in this so strongly, and she's holding out to July too. So she's, making sure that JJ's safe and she's taking care of him, and she's a part of it. Like, she doesn't want to leave where she's at too. Maybe they have her brainwashed. But like I said, I know it's a small chance, probably a really small chance, but I'm still hopeful. I really am. Or it could be the other way around, where they believe it so strongly that July is basically going to be the end of the world, that maybe they just did get rid of JJ and Tylee because they figured it's going to be the end of the world in July anyway. How evil she is. Maybe she just wanted these last few months to go live it up with Chad, and didn't want that burden, and figured if it's the end of the world anyway, then maybe they did just get rid of them. Gosh, I don't understand how a parent can do that to their kids, or how anybody can do that to another person in general, but a parent to their own kids, a mother, I just can't fathom it. Okay, guys, I'm going to play this for you.
All right, before we get started, I'm going to review one thing for the audience here today regarding disruptive behavior. Any activity or behavior which is considered disruptive by the court will result in removal from the courtroom. Any spectator who creates a visual or auditory disturbance of the court proceedings may be removed from the courtroom and/or the building at any time at the discretion of me or court security. We'll now call the case Madison County Magistrate Division of the District Court, CR 3320-302, State of Idaho versus Lori Noreen Vallow. Counsel for Ms. Vallow appears at the defense table. We have Ms. Elcox, Mr. Webb, and Mr. Means. Counsel for the state is Mr. Wood and Mr. Rammel. This is the date and time set for an initial appearance. The defendant is also present here in the courtroom. Counsel for defense, in the court pleadings, it designates Ms. Vallow, aka Ms. Daybell. How would your client like to be referred to by the court?
Mrs. Daybell, please, Your Honor.
Right. Ms. Daybell, do you read, speak, and understand the English language?
Yes.
Ms. Daybell, did you fill out a notification of rights form with your counsel prior to the hearing here today?
Yes.
Do you understand your legal rights here today?
Yes.
Do you have any questions about the form that you've filled out or your rights?
No.
All right, we'll proceed forward then. Ms. Daybell, it's my understanding that you've hired these three attorneys that are with you here today, and that's your position that you'd like to retain your own private counsel. Is that correct?
Yes.
Did you get a copy of the criminal complaint as well as the arrest warrant that has been issued in this matter?
Yes.
Ms. Daybell, I can read the criminal complaint in its entirety, or we can summarize it going through each of the charges. Which would you prefer?
We will waive a formal reading, Your Honor.
We'll just go through the counts then, one by one, as well as the penalties. This criminal complaint was filed here in Madison County on February 18th, 2020. It is State of Idaho versus Lori Noreen Vallow, aka Lori Noreen Daybell. It charges the defendant with 5 different counts. The first count is desertion and non-support of children or spouse. That count is a felony under Idaho law, Idaho Code 18-401, Section 1. The punishment is up to a 4-year maximum imprisonment in the state penitentiary and or up to a $500 fine. It designates or alleges that the defendant, Lori Noreen Vallow, aka Lori Noreen Daybell, on or between the 23rd of September 2019 and the 18th day of February 2020 in the county of Madison, state of Idaho, did desert a child under the age of 18, to wit, JV, date of birth 5/25/12, who was dependent upon the defendant for care, education, or support with the intent to abandon JV. Ms. Daybell, do you understand what count 1 alleges, as well as the maximum penalties?
Yes.
Under count 2, it is that same charge, desertion and non-support of children or spouse. It's also a felony under Idaho Code 18-401, subsection 1. It is punishable by up to 14 years in the state penitentiary and or up to a $500 fine. It alleges that the defendant, Lori Noreen Vallow, aka Lori Noreen Daybell, on or between the 8th day of September 2019 and the 18th day of February 2020 in the county of Madison, state of Idaho, did desert a child under the age of 18, to wit, TR, with a date of birth of 9/24/2002, who was dependent on the defendant for care, education, or support with the intent to abandon TR. Ms. Daybell, do you understand what's been charged in count 2 as well as the maximum penalties?
Yes.
Ms. Daybell, count 3 is a misdemeanor under Idaho law. It's the charge of resisting and or obstructing an officer, a violation of Idaho Code 18-705. It's punishable by up to 1 year in the county jail and up to a $1,000 fine. It alleges that the defendant, Lori Noreen Vallow, aka Lori Noreen Daybell, on or about the 26th day of November 2019 in the county of Madison, state of Idaho, did willfully delay and or obstruct a public officer, to wit, Lieutenant Ron Ball of the Rexburg Police Department, in the discharge of his office by giving false information regarding the whereabouts of a child, JV, date of birth 5/25/2012, and thereby delaying the search for JV. Ms. Daybell, do you understand the charge in count 3 as well as the maximum penalties?
Yes, I understand the charge.
Count 4 is also a misdemeanor. It's a charge of solicitation. It carries with it up to 6 months in the county jail and a $500 fine. It's a violation of Idaho Code 18-2001. It alleges that the defendant, Lori Noreen Vallow, aka Lori Noreen Daybell, on or about the 26th day of November 2019 in the county of Madison, state of Idaho, with the purpose of promoting or facilitating the commission of a crime, encouraged and or requested Melanie Gibb to engage in conduct which would constitute the crime of resisting and or obstructing an officer. By requesting and or encouraging Melanie Gibb to give false information to law enforcement regarding the whereabouts of a child, JV, date of birth 5/25/2012. Ms. Daybell, do you understand the charge of count 4 as well as the maximum penalty?
Yes.
The last count is count 5. It's a misdemeanor under Idaho law. It's a charge of contempt, a violation of Idaho Code 18-1801, subsection 4. It's punishable by up to 6 months in the county jail and up to a $1,000 fine. It alleges that the defendant, Lori Noreen Vallow, aka Lori Noreen Daybell, on or about the 30th day of January 2020, in the county of Madison, state of Idaho, did willfully disobey a lawful court order in Madison County, case number CV 3320-45, by failing to physically produce minor children JV and TR to the Rexburg Police Department and or Idaho Department of Health and Welfare within 5 days of service of the order. Ms. Daybell, do you understand what's been alleged in count 5 as well as the maximum penalty?
I understand.
Ms. Daybell, do you understand that all of those charges and their maximum penalties could run consecutively, one after the other, or they could run concurrently, meaning at the same time? Do you understand that?
Yes.
In addition to the rights form that you've already filled out, pursuant to Idaho Criminal Rule 5, I'm also going to give you the following rights. Number 1, you are not required to make a statement, and that any statement made by you today can be used against you. If your witness could only be here by the 19th, that we allowed that witness to testify.
Further, Your Honor, there is probably no greater assurance that Lori will appear before this court and any other court assigned to preside over this case because of the droves of people that she has following her every move, even before she was charged. She has TV cameras in her face. She has people following her. It is built-in pretrial monitoring to a level I have never seen before. It's more effective than any sort of surveillance that law enforcement could put on her. She cannot go anywhere without cameras and people scrutinizing her every single move. She poses no flight risk whatsoever. She is intent on defending against these allegations and proving that she is innocent, despite the fact it's the state's burden to prove her guilty beyond a reasonable doubt. If the intent of the high bond as originally set in this case was to ensure that Lori was transported back to Idaho, she is back. And as I stated, she is eager to defend against these charges. Regardless as to whether she has been tried and convicted in the court of public opinion, Your Honor, here today, Lori is innocent. Lori will absolutely abide by any pretrial release conditions, any sort of monitoring that the court requires, but there is simply no basis for a bond this high, and it must be reduced given the charges that she is facing. For those reasons, Your Honor, we would ask that you grant the defendant's request to reduce bond.
Ms. Selcox, just so I'm clear, if your client were to bond out, I don't need her address, but where would be her expected place of residence be?
She'll be residing locally, Your Honor. I can provide that address to the court under seal if the court would like to do so, but given the media attention, I would rather not put that on the record.
I understand. Thank you. Mr. Wood, do you wish to be heard?
Yes, Your Honor. I'll address counsel's comments first on how we got here and why the bond for the bill was set at what it's at. This case didn't start as a criminal case, Your Honor. It started as a report of 2 missing children who were still missing. November 25th, Rexburg police late in the day get notice that this young child is missing. Within 24 hours, they respond. When they respond, they're given verifiably false information by the defendant. And so the next day they obtain warrants and to search the residence for the child. And at that point, the defendant is gone. Now, they say it's a planned move. Maybe they did plan to move to Hawaii. However, they clearly left very quickly as soon as they were contacted by law enforcement. The vast majority of their belongings were still in that apartment. And so the investigation continued. A Child Protection Act was filed, and an order was given for Lori to produce the children, for the defendant to produce the children, which she did not do. I'll address this issue that she informed law enforcement that she would turn herself in. It's kind of hard to trust someone to turn themselves in on a warrant when a simple welfare check caused that person to leave. Your Honor, as counsel stated, Idaho Criminal Rule 46 lists the factors to be considered at setting bail. So we'll go down through those. The defendant's employment status and history. As far as we're aware, she's not presently employed. No argument can be made that she's at a risk of losing employment. Their financial condition. We are aware that the defendant's new husband received a substantial sum of life insurance proceeds from the death of his wife last October. Obviously, those funds provide them with the ability to relocate quickly and to stay away from Idaho, which we believe they've already done. The nature and extent of the defendant's family relationships. The defendant's only family here is her new husband. And it's important for the court to consider that at a bail reduction hearing in Hawaii, very recently, the defendant's attorney represented to the court that her husband lived in Hawaii, not in Idaho. Now, we understand that the defendant does have a house here, close to here. However, the fact that the defendant represented to a Hawaii court that they lived in Hawaii shows that they consider their ties not in Idaho, but in Hawaii. And in terms of her past residences, if we go back to the last year, it gets a little more concerning. In regards, since this last summer, the defendant has lived in Arizona, Idaho, and Hawaii. And quite frankly, the circumstances under which she left Arizona, which was soon after the killing of her estranged husband by her brother, and the circumstances in which she left Idaho, which was the same night Rexburg police did a welfare check on her, give the state serious concern that she is a flight risk. Factor 4 is the defendant's character and reputation. Since this last summer, there has been a clear and alarming pattern in the defendant's life. There are literally 3 active investigations of suspicious deaths that she is related to. And I want to be clear, Your Honor, we're not saying she's been charged in those. And we're not saying the court should treat her as such. However, she is related to each of those deaths, and it is alarming to the state. As we've said before, Your Honor, the defendant tried to mislead Rexburg law enforcement about the whereabouts of her children. In furtherance of that, she tried to convince a family friend to tell the Rexburg police that the children were with her in Arizona, even though they weren't. And that, Your Honor, the defendant has a history of defying court orders. In the child protection case associated with this case, she refused to produce her children as ordered. In a 2009 child custody case in Travis County, Texas, the defendant was found guilty of 7 different counts of civil contempt. Factor 5, the persons who agreed to assist the defendant in attending the court at the proper time. Again, Your Honor, that's pretty much limited to her new husband. And due to the fact that he and the defendant left so abruptly before, we don't have a lot of assurance from that. Factor 6, the nature of the current charge and any mitigating or aggravating factors that may bear on the likelihood of conviction and the possible penalty. In regard to those factors, Your Honor, the state would first point out the language of Idaho Code 18401, which states that it is a felony for anyone having a child under the age of 18 years dependent upon him or her for care, education, or support, who deserts such child in any manner whatever with intent to abandon it is a felony. In any manner whatever. That's a broad statute, Your Honor. It's broad because it deals with protecting children. So the aggravating factors bearing on the likelihood of conviction in this case include the following: that the defendant established a residence in Madison County, Idaho, with 2 minor children. Those children ended up being reported as missing, and the defendant left the state without them. The defendant defied a court order to produce those children. One of those minor children is only 7 years old and has special needs which require medication and medical attention. Both of the minor children received Social Security benefits, and the defendant continued collecting the children's Social Security benefits into her own account, both after the last known sightings of the children in Madison County and continuing into Hawaii. And it's important to note that case law related to the desertion of a minor child and Idaho Code 19302 make it clear that this court has jurisdiction over acts of desertion both here in Madison County and continuing into Hawaii. And the most aggravating factor, Your Honor, one that's quite frankly heartbreaking and is the reason why there's so much media attention, is that the children are still missing. And the defendant has not only misled law enforcement in their efforts to find the children, but she has completely and utterly refused to aid in any attempts to find the children, even before charges were filed.
All of the decades that she has been alive does not have a single criminal law violation whatsoever. It goes without saying that she also does not have any failure to appear in any criminal case. The prosecutor referenced the specific code language that she is charged with. I would note that this statute doesn't have a definition for abandon. However, the Child Protective Act does. And in those statutes, the prima facie evidence of abandonment is established when there hasn't been the parental relationship hasn't been maintained for a year. Pursuant to the charging language and the time period that the state chose to charge in this case, Lori isn't even at half that time. So I respectfully disagree with the prosecutor's assertion that Lori will be convicted of these charges. I have represented to the court, as I have a duty of candor to the tribunal, that Lori will be residing locally. And as I indicated, I'm happy to provide that address to Your Honor under seal to protect Lori in this case. The prosecutor has gone through a litany of allegations for which she is not facing any sort of criminal charges whatsoever, and not criminal charges in this case. Those should not be considered by the court for purposes of this case and setting bond pursuant to Idaho, the factors listed in Idaho Criminal Rule 46. We would ask that you grant the defendant's request and set bail as requested in this matter.
Thank you, Ms. Alcox. The court has listened carefully to the argument of both the state and the defense. The court has reviewed in detail and in full Rule 46 of the Idaho Criminal Rules. The court has also reviewed the Idaho Bail Act, Title 19, Chapter 29, specifically under 1929-04. It designates that the court may release a person on his own recognizance or set an amount of bail, and may impose any conditions of release. In making these determinations, the court shall consider the following objectives. Number 1, ensuring the appearance of the defendant. Number 2, ensuring the integrity of the court process, including the right of the defendant to bail as constitutionally provided. Number 3, ensuring the protection of victims and witnesses. And number 4, ensuring public safety. The court has taken all 4 of those factors into consideration, as well as all 10 factors under subsection C under the Idaho Criminal Rules 46. And based upon the argument that I've heard here today, the court is going to reduce bail. I'm going to reduce bail to the amount of $1 million. I recognize all of the factors that have been looked at here. One specific thing that the court notes in setting such a high bail amount is that there is a pending court order, and to my knowledge there has been nothing set forth regarding obedience to that court order pertaining to lining the court out with information on where the 2 children are at the Department of Health and Welfare or at the Rexburg Police Department. So with that, bail will be set at $1 million. If bail is posted, there will also be the following conditions that are ordered. Number 1, there will need to be a waiver of extradition signed from any and all jurisdictions to be brought back here before the court. Number two, I'm going to require that Ms. Daybell not leave Bonneville, Jefferson, Madison, and Fremont counties. If she were to leave any of those counties while this case is pending without permission or authorization from the court, that would be a violation of the terms of bond and release. I'm also going to order that there be an ankle monitor that is placed on the defendant. That will need to be all lined out before she's eligible to bail out. It will be monitoring 24 hours a day, 7 days a week as to where the defendant is. And then lastly, I'm going to order as a term of any release or bail that the defendant appear for all court appearances, that she maintain contact with her counsel, and that she abide by all the laws of this state, this country, this county, and this city. Mr. Wood, do you have any questions about my ruling regarding the reduction of that bail?
No, Your Honor.
Ms. Elcox?
Just briefly, Your Honor, does the court have a specific form for the waiver of extradition you would like us to use?
I think the jail has one. Does the jail have a form that they have? If you'll communicate with the jail, I think they do have a form. If not, why don't you submit the one after you've gotten approval from Mr. Wood? You can submit that after she signed it, and the court will review to make sure it meets my satisfaction.
Yes, Your Honor. And do you have, would you like us to coordinate setting up the ankle monitor through the jail, or do you have a specific agency you would like us to use?
You can coordinate with the jail and or the sheriff's office. They'll know that information. They may have someone that they usually use. I'm not sure of that. If you have a preference, you could provide that information to them, and if there's an issue, it can be brought before me for my approval. Any other questions?
No, thank you.
I believe that takes care of everything that we're here for today. In a moment, I'm going to leave. When I do that, the audience is going to be asked to rise. I'm going to leave the courtroom. After I leave, I'm instructing everybody to be seated again. There will be the removal of the defendant from the courtroom, and then everybody will be excused row by row pursuant to court personnel here today. With that, we'll be in recess.
All right. First, out this side door here.
Wow, how mad did Colby look? He looked like he was so mad. He's probably so mad at his mom. Like, I can't even imagine. You know, well, I guess I can't even imagine having a mother like that. But, I mean, can you imagine your mom acting like that? He looked mad.